Good evening, chat. Sorry for the delay by a couple minutes, but we have day 10 of Brendan Banfield. We are closing arguments. Yeah, I can't imagine this is going to work out for him, but spoiler alert, the jury does not make a decision by the end of Friday, so we're back to, we'll be back Monday, which I'm really kind of like, I thought it'd be over by now, but apparently not. So, yeah, sucks a lot, but oh well. Let's see here. So let's get started. Yeah, the jury had a hard out. Oh, a couple of minutes later, Matt. I thought I said 6:10. So Sean Sandwich Sundry for $5 says, "Great seeing you on LBL. Also, thank you for streaming this trial. I need to get caught up." Well, thank you. After this is over, guys, we will go over to the bench and start painting on some stuff because we have a new set of Africa Corps guys to get in the game. So a new set of guys, and we'll work on those. Afton, how you doing? Hope you're doing well. You call it the long slog. As lawyer math, suffer, Edward Scott, suffer my math, suffer that. All right. Oh, where is? Oh, what the heck is? Let's see here. We are, hold on, I gotta grab, where the heck is it? It's not coming up. I already typed it in. Court TV, you screwed me over. There we go. Now I found it. They make this so hard. So here we go. Brendan Banfield, day 10. Let's get to this chat.
All right. Good morning.
Good morning, Judge. How are you?
Good.
Morning.
I don't know how am I guess is the
I think we're
question.
good.
Okay.
Your Honor, the Commonwealth has elected to proceed on one count of aggravated within 3 years and one count of aggravated same transaction. We have presented one instruction for each of those counts. It is the model. We have added to that one instruction that had not been previously provided for child endangerment. We will not be going forward
And
on
I'm going to take out the child abuse one.
abuse and
correct?
neglect. Exactly.
Okay.
And then we have withdrawn, and I can tell you which letters,
Okay.
instructions
Right.
that were related to
Sure.
first degree, second degree.
Let me hold on a moment. Just for the record, which counts of the 4 counts of aggravated murder are you going forward on?
One moment.
Either 1 and 3 or 2 and 4. I think those are the options.
Right.
But I just want to make sure for the record. Okay, good.
And I'm sure you're right, Judge, but we'll open it really quick and just
Okay,
make sure
sure,
that
absolutely.
our 1 and 3 and 2 and 4 are the same as yours. Sure.
So,
So 1 and 3?
1 and,
No.
1 and 4.
1 and 4.
1 and 4?
1 and 4.
Okay, absolutely, that's fine. Any objection to that then?
No, Your Honor.
All right, so we're going forward on count 1 and 4 of the case number ending in 666. And then for 2 and 3, there's a motion to dismiss
dismiss.
those.
Oh, wait,
so
okay,
no
hold on, I'm
objection
getting
to-
tapped.
No, ma'am.
Wait a minute, hold on. There seems to be a change here.
Sorry, we're gonna read this one more time.
Same after transaction. 1,
One.
4. Same 3-year period, Christine. Yes. 1 and 4. Dismiss 2 and 3.
Okay.
Yes.
Final answer?
Yes.
Okay, 1 and 4. So we're dismissing 2 and 3 with no objection.
No
Okay,
objection.
all right. So 1, 4, and 5 under the case number 666, and then we just have child endangerment on
Which
the
is
one ending in 873. Okay,
count one, Judge.
that is count one.
Yes.
So count two is dismissed
Yes, ma'am.
on that, on 873. Okay, fabulous. So now I have the ones before that we had talked about. Do you just want to go through those?
Yes, ma'am.
Okay,
And I will pass up our new stack. They're clean. They have. the
Okay,
years typed
excellent.
in.
all right, so I had instruction A, which I assume is still the same, correct?
Yes, ma'am.
Okay, and then we'll withdraw instruction B since he did
Correct.
testify. Okay, withdrawn. And then you still have C.
Yes.
Okay, D,
Yes.
E,
Yes.
F,
Yes.
G,
If they stop sticking together, yes.
all right, and then H.
Judge, I have an I next.
Oh, I'm sorry, H is child abuse, so you're throwing
Yep,
that
so
one.
that would be withdrawn.
Okay, fabulous. All right, and then we have I,
Yes.
okay, Q,
So Judge Q would be withdrawn.
Q is withdrawn, I assume without objection.
Without objection.
Okay, Q is withdrawn. Okay, what do you have next? R?
I actually had an L.
Okay, you had L. I switched them around a little bit because.
That's okay because they didn't make sense in that order. That's fine.
Well, not to me, but.
Nope, that's A-okay. I can track.
I could,
So
that's fine, I'll just.
if you're on R next, we would withdraw R.
Withdraw R, okay.
We would withdraw S.
I have M next.
Okay,
M
so
as in
M
Mike.
is in.
Okay, S as in Sam,
S as in Sam would be withdrawn.
okay. N as in Nancy,
Yes.
O,
Yes.
P,
Yes.
T as in Tango,
Yes.
okay. And then I think, let me see, then I have some of his instructions. I think that's all I had for you. So which one would you like to add to that?
So I have L, which was willful.
Willful, okay, you have L.
I do.
All right, do you have a copy?
I
Well,
do.
You got the clean copies,
Yep,
that's
I'm
fine.
gonna
Okay,
pass that
so
up to Your Honor.
we'll add L, okay, and what else?
And then I have U, which is the instruction for aggravated murder 3-year period.
Okay,
And then I have V, which is the instruction aggravated murder, same act or transaction.
okay.
And then I have X, which is the crime of child endangerment.
Okay. And you and B have the waterfalls also?
They do not, Judge.
You're not doing
We are not
waterfalls?
doing a waterfall.
You're just standing on aggravated
We
murder?
are.
Okay, that is your option. Do you want waterfall instructions, Mr. Carroll?
Oh, Your Honor.
No.
I'll stand on as well.
Okay, so we're standing on aggravated murder. You've just made life a lot simpler for me on your decisions, but that is your decision. Okay, so no waterfalls, we're standing on aggravated murder.
Yes, and I'm passing them up with the previously agreed upon new separate so you can put them in as you
Okay.
would like them to appear.
All right,
I also understand we've agreed to defense 2, 4, 10, 12, 16, 20, and 36.
I think that's what I have.
No
Let me make
changes.
Sure, those are the only ones I already had, correct?
Yes,
Correct.
Your Honor.
I have 2, oh, I do have L, okay, sorry. I do have 2, 4, 10, 12, and 16, and 20, and 36.
Yes, ma'am.
Okay, anything to add to those, or that's it?
There you go.
Oh, you guys get a gold star today.
Thank you.
Okay, that is fabulous. All right, so you want to hand me up the, you have the clean copies for your, oh, you already gave me.
Yep.
Okay, I got the clean copies. And do those include Mr. Carroll's, or Mr. Carroll, yours were already clean copied, correct?
The ones that I handed up before were clean copies.
Okay, so I can just insert his in
Yes, ma'am.
yours. Perfect.
And at this point, we owe you a verdict form. Now that you have accepted those
Right, yes, I have
instructions,
those instructions.
we will provide you with a verdict form.
Okay, oh, that's fine. So if you want to provide a verdict form, I can have Shannon do one since it's just aggravated murder now. It's not too
If,
difficult.
if
I can do
that's
that.
just fine.
So we'll do 3 verdict forms, one for aggravated murder, one for firearm, and one for child endangerment.
Yes,
We're on
ma'am.
the same sheet, music? Okay, good. 3 verdict forms?
Ms. Fritzler's asking, do you think we need 2 aggravated murder forms?
Oh, yes,
given
I'm
that there
sorry.
are
I
2 separate?
apologize. You're right. Because you did go ahead and do both the same occurrence and 3
And
years.
3
Yes, so we need 4 verdict forms. Aggravated murder in the same act and transaction, aggravated murder 3 years, firearm, use of firearm, and child endangerment. Okay, we'll get those together.
Perfect, thank you.
And by the end of closings, we'll be able, you can review them before they go back to the jury.
Great, thank you.
Okay,
Your Honor,
Yes,
is
sir.
there an order that you're going to be calling out the jury instructions?
there is. Let me just put it back into the order and I will let you know. And I will actually get copies to you as well.
Okay.
In the order that I'm going to give them, and I'll get one for the court reporter too,
Oh,
Carol.
great, thank you.
So I'll do that. We'll have time to do that, okay?
Okay.
So that takes care of jury instructions. Do I have Ms. Smith here yet? Ms. Smith, are you here? Are you ready for your motion?
Yes.
Let's go. Is that okay?
Yes,
I'd
absolutely.
rather do that than I can go back and put those instructions all in
Yes, ma'am.
order. Ms. Smith, you can just come to the center podium, that's fine. Apologize.
Yeah, guys, we're getting all the housekeeping done, admitting all the exhibits, cleaning all that. Because remember, the jury gets all the evidence. The jury instructions are done. The verdict forms are done. What type of charges they were going to pursue. It's all being cleaned up.
Just want to make sure I have the right Miss Smith. This is for the access motion.
Yeah, okay. Well, you're Ms. Smith, so.
Well, no, I know.
you
I just,
answered.
there could be multiple Miss Smiths, so I wanted to make
Well,
sure.
the odds were pretty good that I had the right person. I know it was set for 9:30, but since we were so organized today, if it's okay.
I don't
with
know
you,
why
I'd
they're
like to go ahead and do it
chasing
now.
waterfalls.
Absolutely.
All right, I've read your motion.
Thank you.
So You don't need to regurgitate it, but anything you want to add to the record, you're welcome to.
Oh, thank you. No, I mean, I appreciate you reading it. And just for the record, I'm Alia Smith here on behalf of ABC and NBC for access to sealed records. And I won't repeat what's in our papers, other than to say I read the Commonwealth's opposition yesterday.
Right.
And I don't think that they offered, the compelling reasons that are necessary to seal, in a public criminal trial. But, the fact that the litigation was concluded in the Daily Press case, which is one of the main.
So they're arguing, ABC and NBC are saying, hey, the case is over, the trial's over, no more prejudice. We want to see all this shit. Good points. I doubt she's going to grant it.
Authorities that we relied on, I don't think is a
Also, thank you,
distinction
EDW.
because the harm that they're claiming here is not to do with jury tampering or jury impact. And same with they try and distinguish the press enterprises cases because in the press enterprise cases, the Supreme Court was dealing with the sealing of the whole entire trial.
Being closed, correct.
Correct. And that's true. And I appreciate very much that most of this trial has been completely open.
400 exhibits and televised. So.
Exactly, and the exhibits available on the internet. But I think the point of the press enterprise and Globe newspapers and all the Supreme Court cases is that every aspect of a criminal trial needs to be open, and if it's not, the sealing has to be justified by on-the-record findings of a compelling interest, and I don't think that's been done here.
Okay, all right, thank you, ma'am. Did you want to respond? I did read your opposition
We
brief.
would submit on our brief.
Spin on your brief. Did you want us to respond, Mr. Kerr? You joined your microphone. Just
Your Honor, I would join in the Commonwealth's position.
all right. Thank you. Okay, you can stay right there. That's fine. All right. So the ruling on the media motion, non-parties ABC and Dateline have moved to unseal certain exhibits admitted during this trial. The court fully recognizes and respects the First Amendment and the fundamental principles of transparency in our judicial system. These proceedings have at all times been open to the public and the media, and the media has not been denied access to any hearing or trial testimony in this case. At the same time, the court does not take the sealing of documents lightly. When considering sealing or unsealing, the court must balance the public's right of access against other compelling constitutional and statutory interests. Here, the constitutional and statutory rights of crime victims. Article 1, Section 8 of the Virginia Constitution, entitled Rights of Victims of Crimes, and Code 19.2-11.01, entitled Crime Victim and Witness Rights, require that crime victims be treated with dignity, respect, and sensitivity, and that their privacy be protected to the extent permissible under law. Victims are defined in relevant parts to include family members of homicide victims, including spouses, parents, children, and siblings. As the Supreme Court recognized in Globe Newspaper Company versus Superior Court, the First Amendment right of access to criminal trials serves the important purpose of protecting the free discussion of governmental affairs. However, that right is not absolute. It may be limited where there is a compelling governmental interest, and any limitation must be narrowly tailored to serve that interest. The court finds that unsealing these materials would add little, if anything, to the public's understanding of the judicial process while substantially infringing upon victims' constitutional and statutory rights. Here, the court finds that the protection of victims' rights constitutes a compelling governmental interest. That interest necessarily limits the public dissemination of graphic depictions of deceased victims, nude victims undergoing life-saving measures, and autopsy images, particularly where such materials would be available for permanent public distribution, download, and reproduction worldwide. The First Amendment does not require the court to permit the exploitation of crime victims or their families by releasing graphic images of their loved ones' bodies for purposes unrelated to public oversight of the judicial process. The victims in this case were a mother, daughter, sister, and a son, brother, and grandson. Their surviving family members' constitutional rights must be considered and respected. This remains a public trial. Of the exhibits admitted into evidence, approximately 400 exhibits are unsealed and publicly accessible on the court's website 24 hours a day. 74 exhibits were placed under seal. The court has reviewed each sealed exhibit admitted in this case to ensure that sealing was narrowly tailored and justified. I will note initially that one category of material referenced in the motion, the co-defendant's interviews with the Commonwealth, were never admitted into evidence and are not part of the court's record in this trial or any pretrial proceeding. Okay, those materials remain in the possession of the parties and are not subject to unsealing by the court. Additionally, the minor child's interview was sealed pursuant to a pretrial motion due to the presence of a minor victim, and that sealing remains appropriate. With respect to the sealed body-worn camera recordings, the moving parties requested that the court redact or excise portions depicting victims' bodies and release the remainder. The court received these exhibits in their entirety as evidence. It is not within the court's role or technical ability to edit, splice, or alter admitted evidence, and the exhibits must be considered as they are entered into the record. All sealed exhibits were sealed pursuant to motions agreed to by the parties at the time of admission. For the record, the court will now go through each sealed exhibit and state the basis for sealing. In doing so, the court does find that certain sealed exhibits do not implicate victims' rights and therefore will be unsealed. Okay, so I'm going to go through it. I'll give you a copy of this.
No, and I appreciate that. And can I just be heard out for one moment on the body-worn camera footage?
You can, but I'm not going to change my mind. Okay. All right. So would you not rather do it? Good. Okay. So let's go through the sealed exhibits. All right. Number 4 is a body cam.
We totally know that feeling about body cam. We know that feeling about the body cam. So we're going to skip all that. We're going to go to the break here. We're going to have it come back. Let's get back to like when they actually come in. We're not going to do we're not going to do the jury instructions. I don't really care to hear those, but we are going to get to the closing arguments. Here we go.
For the attorneys and for the court reporter for right now.
Oh, here we go.
And if we can have the display for the jury activated from our table, and it does include sealed exhibits.
Oh
so
my
we'd ask that they
God.
Be displayed to the
Okay,
gallery.
just to the jury and not
Yes,
to the
please.
gallery.
Thank you.
you.
He goes forever.
Okay. Good morning. Thank you so much, not just for what you're going to do today, but for all of the time that you have spent carefully considering the evidence that we've been able to put before you, for the attention that you've paid, for the notes that you've taken, for the time that you've given up away from your daily lives, your jobs, and your families. Without your work here, Christine Banfield and Joseph Ryan would not be able to find justice. So thank you. The judge has read the instructions to you. They'll go back to the jury room with you, and you're going to have those as your guide in making your decision. I would draw your attention to the fact that you've been given 2 counts of aggravated murder, 1 count of use of a firearm in commission of murder, and 1 count of child endangerment. Talking first about the aggravated murder instructions. They have 3 parts. You'll first need to find that Brendan Banfield killed Christine Banfield and Joseph Ryan. You'll need to find that those killings were willful, deliberate, and premeditated. You'll need to find for one of the counts that those 2 murders occurred within a 3-year period, and for the other count that those 2 murders occurred within the same transaction or occurrence. We know that they were killed during the same event within the Banfield residence, so that should knock that one out for you. 3 years, pretty simple as well. We know that they occurred on the same day. It's the first element that we're going to talk about, that Brendan Banfield killed both Christine Banfield and Joseph Ryan. We know that on February 24th, 2023, he executed his plan to murder his wife and an innocent stranger. He was in love with Juliana. He can pretend that this was a fling, an affair, he'd had them before, no big deal. He was in love with Juliana. He was afraid of losing her. He needed to get rid of his wife so that they could be together, so that they could marry, so that they could have those babies that he was picking out names for. Juliana told us how the plan was crafted and how it played out that morning in the Banfield house. But you've heard directly from our detectives and our experts the uncontradicted evidence of Brendan Banfield's culpability. You needn't rely only on Juliana's story. There has been a plethora of evidence to help you meet your burden in this case. Let's walk through just the highlights. Our digital evidence. While the digital evidence cannot tell us definitively who was behind the screen, we heard that a bunch. We know that to be true. What it can tell us is that Brendan Banfield and Juliana Perez Magalhães are more likely to be the ones to have set up Joe Ryan to come into the house to fake rape Christine on February 24th. There is no digital history, none, of Christine Banfield using dating sites, fetish sites, searching for pornography, talking to other men prior to the January inception of this scheme. Brendan told you that more than 10 years ago, there were incidents of affairs involving rough sex, but you have 0 evidence to corroborate that self-serving statement. Think about the 2 days of Mr. Lidsky's testimony for the defense and the 3 times that Detective Miller was called to this stand. If there was one scintilla of evidence that supported these claims of infidelity, of interest in sexual violence, don't you think you might have heard about it? The FetLife and Telegram contacts all occur on Christine's laptop, frequently while her phone is in use with something completely innocuous. You remember the frozen tickets, the Lululemon shopping, the family vacations the day before the murder? 2 devices, 2 different people. The FetLife and Telegram usage only ever occurred when Brendan Banfield and Juliana Perez Magalhães are in the home. Is it at all plausible that this woman wouldn't take advantage of an empty house to engage in her plans for adultery? That on the 2 weekends that her husband and the nanny are out of the house, those are the 2 weekends where we see 0 FetLife activity, 0 Telegram activity? Let's look at the chats themselves. Slide 1. How many potential targets were turned down by Juliana and Brendan because they wanted to meet in person first, because they wanted to talk on the phone, because they wanted pictures that included Christine's face? Does this make any sense for someone seeking a new relationship in an area of sexual exploration that would be new to them? Why would the real Christine Banfield have been concerned about taking these safety precautions? For that matter, why would the real Christine Banfield have been searching for someone who was willing to engage in knife play when she had a blood clotting disorder? Why would Christine use a phone from a gym bathroom, a photo from a phone taken in a gym bathroom when she has all of these far better pictures available? That one keeps stumping us. There are so many more whys, and I'm sure you have plenty of them in your own heads, but the answer is the same to all of these whys, because it wasn't Christine, it was Brendan Banfield with the help of Juliana. Let's talk about our physical evidence. You heard from Detective Leach, Dr. Kessler, Ms. McCarthy, Dr. Greenspoon, Ms. Colombo. She was up there forever with all those lab sheets. They gave us a million things to think about. Slide 4. Christine Banfield died as a result of 7 stab wounds to her neck. She suffered massive blood loss. Next, the knife Brendan used to kill her was a kitchen knife with an approximately 4-inch blade, the kind you use for chopping up vegetables. This was the knife that Joe Ryan brought because Anastasia asked him to. This was not the killing knife that Brendan Banfield had envisioned for his scheme. Next, Joe Ryan was shot twice. Once in the head by Brendan Banfield, incapacitating him. A second time by Juliana in the chest, tearing a large hole through his heart and lodging in his spine. His wounds were rapidly fatal, according to Dr. Kessler, and we saw that there was little to no blood from the chest wound. Iris Daly-Graff told you that he would have been incapable of movement following that second shot. Next. We saw evidentiary confirmation of the affair. The semen stains on Juliana's bed sheets. We also saw the photos of Juliana's clothing moved into the primary bedroom when the search warrant was executed in October following the murders. We saw the photos of Brendan and Juliana together, both before and after the murders. Her photos from her Instagram, their family photos in the bedroom after the murder. We saw the records from the shooting range for the purchase of the gun and the training of Juliana to shoot it. Slide 8. We saw the deactivation of the automatic locking feature on the front door at 5:47 a.m. the morning of the murders, done from Christine's phone by the person who knew how the locking system operated, Brendan Banfield. We saw Christine's phone turned off at 6:46 a.m. and hidden in a drawer in a bar table in the kitchen. This is just not where you keep your phone. This is not where we heard that this woman kept her phone. This is not where a person who's about to engage in potentially risky behavior puts her source of help. A floor away, turned off, in a drawer, off to the side of the kitchen. Just doesn't make sense. We saw Brendan Banfield drive to McDonald's and hang out, waiting for the call from Juliana. We see their call records, 10 and 11, between Juliana, Christine's phone, which is turned off, Brendan, Christine's phone, which is turned off. They're creating a record. It's a plan. It is premeditated. We see this false attempt to check in on Christine so that they can tell the story to the police when they arrive that they did everything they possibly could. Next, we see the lock at the top of the basement door that Brendan Banfield did not think to engage to protect his daughter. Even under his own version of this event, he agrees he didn't think about it. He left his 4-year-old child in the basement with guns out, stranger in the house, and something happening that caused him to be concerned. We heard the 911 calls. We have a hang up at 7:47 with Joe moaning in the background, and then a 15-minute gap before anyone calls 911 back. 8:02, 15 minutes between when someone in that house thought the police should be there and when they finally asked for help. We saw the body-worn camera and the photos from the scene, blankets piled near the bodies, Brendan Banfield kneeling on this blue towel, the towel that has very little staining, completely inconsistent with having been used to stop the flow of blood coming from Christine's neck. We heard that the carpet was soaked through to the subfloor. We saw Brendan Banfield's handcuffs that he didn't use, magazines full of bullets he didn't shoot, collected from him after the murders. And finally, the blood evidence. You heard from Lieutenant Giacchio and former Deputy Chief Ruch that it was Iris Daly-Graff's report that finally pushed this case over the edge and brought the charges against Mr. Banfield months before Juliana decided to flip. That's how strong this evidence is. That's how reliable this evidence is. Ms. Daly-Graff walked us through so many inconsistencies in this scene, proving that it had been manipulated. And you heard absolutely nothing from the defense about this evidence. Mr. Banfield gave you zero explanation for any of this evidence. Slide 15. They have provided no explanation for Christine's blood smeared on the right hand of Joe Ryan, leaving voids between the fingers. They have no explanation for the blood smeared across the top of the right onto the left, leaving that void on Joe Ryan's hand where they had been overlapping. Next. For that matter, you have no explanation from defense for how his hands came to be in that position, neatly folded on his chest, covering the bullet wound that penetrated his spine, immobilizing him? How could that have happened if you are to believe Mr. Banfield? There's been
He's
no
got a
explanation
point.
for the bloody hand-like smears
Correct.
on Joseph Ryan's jeans containing Christine Banfield's DNA. There's been no explanation from defense for how his jeans ended up bunched under his rear. Next slide. There's been nothing to tell us why a mixture of Joseph Ryan and Christine Banfield's blood, a mixture, could possibly have been on the inside of his waistband at the buttonhole, on the button, and on the zipper. Nothing from the defense to explain how Joe Ryan could possibly have manipulated his pants after being shot in the head, given that no other bleeding wounds were present. If his blood is on those pants, on that button, on that zipper, he was bleeding when they were touched. How could he, Joseph Ryan, have been the one to touch his button, his zipper, the waistband of his pants, to pull them down in that fashion? Brendan told you he never touched Joseph Ryan. And yet we have distinctive finger-shaped parallel lines on Joseph Ryan's arm and small circular stains consistent with blood having been dropped from above while Joseph Ryan lay on his back. Next. And then there's the blood on Joe's hip. Blood that traveled onto his body and then ran down to the floor with the assistance of gravity while he lay prone. It couldn't have come from his chest. That wound barely bled. He was laying down when blood was shed. Makes it pretty impossible that he stabbed Christine Banfield. Next. On the other hand, Brendan Banfield has cast off on his jeans. He has blood all over his hands.
The blood.
The blood stains on the backpack don't line up with the position of its contents. The blood on Joe's face is not consistent with his final position. And I'm back to Joe's hands. This scene was manipulated.
Not
And it
that
wasn't by
Chad.
Joe. It wasn't by Christine. And according to him, Juliana didn't do it. You have zero explanation from the defense as to how all of this blood evidence can be as it is. The Commonwealth gave you an explanation. Brendan Banfield and Juliana Perez Magalhães colluded to kill Joseph Ryan and Christine Banfield. That makes sense. They created accounts, they chatted up potential victims, they got Joe Ryan into the house, and then they shot him. Brendan stabbed Christine, let her bleed out on the floor, and then dripped, smeared, and wiped her blood on Joseph Ryan's body to make it look like he had attacked Christine. Then they called the police. Brendan let Juliana take the fall, and it took a little bit of doing, but here we are, and it's his turn to be held accountable. All of this evidence can leave you with no doubt that Brendan Banfield killed Joseph Ryan and Christine Banfield. That is the first element of the aggravated homicide statute. The hard work is done. Element 2, that the killing was willful, done with a bad purpose, intentional, and deliberate. There can be no question in your minds as to the intentionality of this act, the deliberateness of this act. You must also find that it was premeditated, that at some point before the killing, he decided to kill Christine and Joe. I believe that we presented you with that evidence as well. For one of the offenses, you find that he killed 2 people within 3 years, as we've identified, same day, definitely within 3 years. For the other offense, you find that it was 2 people killed during the same transaction or occurrence. They were both killed in the room as part of the same plot, by the same person, same transaction or occurrence. The second offense is for the use of a firearm in the commission of the murders. We know from our experts that Joe Ryan died of his multiple gunshot wounds, one of which came from Brendan. If you have any question about whether or not Brendan can be held responsible when Juliana also shot Joseph Ryan, you'll have instruction O, that is concert of action. So I'm going to read to you what it says. If there is concert of action with the resulting crime, one of its incidental probable consequences, then whether such crime was originally contemplated or not, all who participate in any way in bringing it about are equally answerable and bound by the acts of every other person connected with the consummation of such resulting crime. Virginia makes it easy. Translate. If you think that Juliana Perez Magalhães and Brendan Banfield were working together to kill Christine and Joseph Ryan, then Brendan can be responsible for Joseph Ryan's death, regardless of which bullet did the most damage. It's not a test of either or. They were working together. That makes him equally responsible. The last charge is the endangerment to Valerie. So while in his custody, that the defendant willfully or negligently caused or permitted the life of such child to be endangered. He made it out to be Juliana's idea, but he brought Valerie into that home. He left her in the basement, knowing that Joe Ryan was upstairs, He left her in the basement while he shot and killed Joe Ryan. He left her in the basement while he stabbed his wife. He could have locked the door. He could have done this on a day she wasn't home. He could have made arrangements for someone else to have her overnight, but that didn't work with his plan. So he's guilty of this offense as well. I appreciate, again, all of the attention that you've given. I appreciate, again, all of the hard work you're about to face. Please be thoughtful in your deliberations. But at the end of the day, I don't think that there can be any reasonable doubt that Mr. Banfield has committed each and every one of the offenses that we have put before you today. Thank you.
All right, thank you. Cross-examination, Mr. Chair. I'm sorry, closing arguments?
Sarah, may I bring a bottle of water up in front of you?
You can.
Thank
You just need to get the microphone.
Yeah,
I mean, that's very well put together. Notice I think she's saving stuff for the end, but she didn't even focus on the things like the boss. Like, I really think she should have focused on, think about all the things we showed you in these stories that don't make sense. All the little lies. You know, everything he said was a lie. He lied to you about what he was going to do for work. You know, he lied about everything. Like, I think they should have introduced it all. I wonder if they're waiting until their rebuttal, but it's just a little weird why it's going this way. So, yeah, it's pretty short, but you know what? I think there's something to be said in a case like this. The more you dwell on everything, the more it can make it confusing to people. So if you try to focus on the minutia, people are going to get lost. And I kind of agree with that idea. I assume that's kind of where she's going with that. And I think you have to do it that way. He lied because he was nervous. Okay. Okay. Totally believable. V2 me this is, are you wearing pants? I'll let you draw your conclusions, chat. I'll let you draw conclusions.
Good morning, ladies and gentlemen. Can you hear me? That's been a little bit of a problem, but I have it right on me at this point. I join in the Commonwealth's thanks for your attention, for the time that you put into this. I intend to present to you with highlights of many of the things that we went through, but I can assure you I'm not going to be going through the evidence that's already been moved in. And it took a long time, and you were very patient, and everyone was very patient.
I'm sorry.
Is that better?
Just further up.
Can everyone hear that? Okay, I'll try to speak a little louder. Ladies and gentlemen, I join in thanking you for your time, for your attention. You could see over the nearly 3 weeks that everybody was attentive, and that's something that is something that's crucial to this process. And so I thank you. When my children were younger, I used to walk out of the house and tell them, I'm going to defend the Constitution. They didn't have any idea what that was, and oftentimes that became, okay, whatever, Dad. I was a prosecutor then. I was a prosecutor in Fairfax County. And what that meant to me was you presented a case, no matter who it was, you presented a case where you looked at all possibilities and you looked at all evidence to determine and to make sure that you were pursuing someone that the evidence would support. In this case, this was quite unusual. When we first met for the initial opening, I talked to you about some things that I thought you should look into. I thought that you should have an ear towards what is it that they're going to present as evidence. And even I was surprised that the evidence that ultimately was presented by the Commonwealth was actually from my case. The only people that were called to testify from the Commonwealth's case in chief were for body cam video, police officers, a couple of those, and Detective Terry Leach. And he was the one who identified all of the scene photos. He identified many of the pieces of evidence that were brought in. And he was able to talk a little bit about things such as the blood stains on the gun, the blood stains next to the bed. And what he told you, ladies and gentlemen, this was the extent of, I think, their testimony in their case was that there are numerous things within this scene that we can see in pictures, but they were never tested. There are numerous things that became the centerpiece of the fantastic story that the Commonwealth tells, yet they were never tested. For example, if I were to have the opportunity to cross-examine, say, the chief detective of this case, I might ask, why wasn't there fingerprints done, or even DNA, of this gun safe that we hear about? We hear Juliana goes into the back bathroom and talks about getting a gun. It changes a little bit over time, but if...
That's interesting. This is an interesting tack he's going on. Let's see how this works.
Someone had said they went to the gun safe, because we're talking about guns, we're talking about shooting, why wouldn't there be some sort of evidence to either corroborate or preclude that possibility? I asked Detective Leach, he says, well, it's really up to the forensic examiners. They make the decision. In looking at the scene, you'll notice in the body cam video that you're going to be reviewing, there's a point when first responders come in and you see Brendan kneeling down next to his wife, rendering aid. He just shot Joe Ryan. He testified yesterday, he puts the gun down to his right, which is where his holster is. And he also indicates to you in his testimony yesterday that he moves the knife away from Joe Ryan. The staining on the bed where my client put the gun for the first responders, because whenever there's any sort of a shooting, you have to make sure that you are nowhere near the gun in the event that you're perceived as someone who's hostile. He puts it to the corner of the bed, and the questions that remain were, did anybody test the blood on that gun? And you hear from Detective Leach, you can't do that. It was already test fired, and that would be potential for contaminant. Now, we didn't test the stains down on the floor where the gun was lying in before it went up on the bed. And we didn't test the gun, which appeared to be something that a serologist could just take a swab of. Yet there's some significance placed on the fact that there was a blood stain where the gun was when it had been sitting in a puddle. And so that actually was tested. In terms of the blood stain pattern analysis, which appears to be the Commonwealth's main focus of the case now, there are questions about many of the things that Ms. Sands says were never tested. And so the conclusions that are being reached in terms of Brendan Banfield did this, he did this, he did this, based upon whatever blood analysis, is oftentimes not considering the fact that it was never tested. We don't even know whose blood it was. Those kind of things are important. And so let's go back to defending.
Technically, under law, Juliana can't own a gun because she's not a permanent resident. So her owning a gun is actually illegal. So you never want to do that for a non-citizen. Unless they have a green card or very rare visas, you never want to do it. And the only visas that would apply are visas you've never heard of. So don't ever get guns for non-residents and visitors can hold a gun as long as they're around you, but they can't by themselves. And this idea that Brendan bought a gun for her, just, wolf, would not ever recommend that tactic.
In the Constitution, when you are charged with presenting a case, and I chuckle a little bit when Ms. Sands says, we haven't proved anything, we haven't shown any evidence. All we've done is show evidence. All we've done is try to get the truth out there. My client doesn't have to testify, yet he gets up there and he tells a story. He's a philanderer. We can conclude that. It's horrible. It's a horrible situation to be in. He had affairs. He accepted that. He told you, ladies and gentlemen, exactly what was going on and exactly how it went. On cross-examination, he admitted to communications that were provided, which were letters between he and Juliana when she was in jail. This is about the truth. In the beginning, you heard our duty is about fairness, our duty is about being just, all those sorts of things. Yet you don't put on any of your detectives. She's referring to the expert that they have that I called. I called 3 times. And you saw his demeanor. He was very uncomfortable. Why would he be uncomfortable? Why would he have been uncomfortable talking about his work? And we dug for it. And he ultimately said, the executive summary and the data remained the same. The only thing that changed is Juliana Perez Magalhães' statement. Excuse me one second. So there, number one, that's the first time that anyone in this case, which was when I called him, conclusively said the entire catfishing theory changed upon her plea deal. So let's talk a little bit about confirmation bias, or I think we referred to it when we were talking in closing, or when I was talking in closing about a rush to judgment. You've heard from detectives from Fairfax County. Detective Smith came up and she told you the catfish theory started within weeks of the event. She says, that's not how we do it. We look to the evidence and we follow the evidence. Seems like a pretty reasonable way to go. And that was something that I asked of pretty much everyone that was in some sort of investigatory capacity. That is the way cases go, is the evidence leads you where you're going to go. But lo and behold, what we find out is that that theory is being peddled by the 2 people in command staff, actually the 3 people in command staff that you also heard from. You heard from from Mr. Bruch, formerly Deputy Chief Bruch, that when Brendan Miller presented his findings, well, first of all, he said, I didn't agree with his report. And I said, well, what if any analysis of the raw data did you do in order to make that statement, I don't agree with this report? He said, well, it wasn't that. I don't know about the data, though he said he was a computer forensic PhD. He didn't take the time to do that. So I said, okay, well, did you ever have Detective Miller come in and walk you through it? Like, show your work? Well, we talked about it quite often, but did you, in fact, have him go through everything that he did to arrive at his work? No, we didn't do that. He speaks to Lieutenant Giacchio at the time, who appears to have a direct line to him, obviating anybody else within the command staff. And what you'll see, and you'll see it in the evidence, there are emails where soon after Juliana Perez Magalhães changes her story, there are emails to Sergeant Ames. And you remember Sergeant Ames, he came to the stand based upon my subpoena and my calling him. And Sergeant Ames was not comfortable. And you can see any of these police witnesses are just not comfortable coming to the stand on my subpoenas and answering my questions. But he did answer them. And what you saw were emails. Those emails were essentially, they were just kind of forwarding it up the chain so that his supervisors knew. And he was very candid about it. I was new. I wasn't sure how to deal with a situation like this. I'd never dealt with a situation like this. But what the situation was Detective Miller's executive summary being sent up the chain to Sergeant Ames, who was in a different division than Lieutenant Giacchio, saying there's different ways, there's 3 different emails that you'll see. Brendan Miller has got to look over this, and he's got to go line by line and explain how he got it wrong, things such as that. The final one is to Sergeant Ames. I can tell you that every single conclusion in his report was wrong. He's going to have to do something in order to, and
He's not rambling, guys. He's actually doing a pretty good job pointing out they made this guy and the stories weren't adding up. He's actually doing what he's got to do here. So I give him points right now.
it's kind of, essentially, he's going to have to change this report because it needs to conform with the proffer of Juliana Perez Magalhães. So that's twice now. 2 different people that I called to the stand that essentially confirmed that everything changes when she comes in and testifies. Let's get back to confirmation bias, rush to judgment. When you have people of in a supervisory nature, you have a command staff chain of command, and the highest people are pushing you on your work product. That's why you look like the people that are up here testifying, because they're sitting on the fence. They're sitting on a razor, and neither side is good for them. But they came before us and they testified. And they testified as to the truth. Detective Miller spoke the truth, and you could see it. Detective Miller, his work was concurred by Mr. Litsky, who you heard for quite often during this period of time. And it was peer reviewed and it was concurred by someone, a third party. You heard Detective Miller say, that's never been done in Fairfax County. You heard him say, I didn't ask for that peer review. He didn't know who asked for that peer review. Why would you want a peer review of something if it wasn't for it to change? So once again, not happy with that. Not happy with the work product. There's nothing to indicate in Detective Miller's background anything but stellar expertise. But he wasn't introduced as an expert for the Commonwealth. Now, this is where this whole theory went wrong. They discredited him, they disregarded him, and they didn't listen to him. And that's a problem. That's a problem for their case. Because there are things in digital forensics that had he been involved with the group that was talking to Juliana Perez Magalhães, he would have been able to guide them in terms of this is where the digital forensics is in conflict with you. And you heard me testify, or I'm sorry, you heard me ask questions of many of these detectives who might have been involved. Did anybody ever challenge her? Were you present when she recanted for the first time? Well, we couldn't ask that of anyone because the detectives that were in the room have not been called. The detectives that were in the room, I didn't call. And so we don't know anything, but we heard Detective Miller, and he had viewed it, and he said, when I asked him, were there challenges to what was said? He said, no, it was pretty free-flowing. To me, that tells you that whatever the story you're telling us is great, because we're getting Ryan and Banfield based upon that. Once again, confirmation bias. The first few weeks after the death of Christine Banfield becomes this theory of catfishing, which is what Juliana Perez Magalhães provides to this. Now let's talk a little bit about digital forensics. And I'm not going to try to use the computer to show these to you because that was excruciating at times. But I think we've gone through it with significant enough detail.
At least he admits it was
That when
excruciating.
you go back to look at the exhibits, and I'll tell you which exhibits if you wish to write them down, you're going to be able to see exactly what Mr. Litsky was saying. It's complicated. It's been complicated for me since the beginning, but it's not necessarily an easy grasp. But I would ask that you take the opportunity. You're going to have all this evidence to review this particular area. So some of you may have been asking about January, or may wonder about January 9th. That's a significant date in this investigation, because that's the day when the Gmail account, called the suspect Gmail account, was started. Let's just look at how Juliana Perez Magalhães managed this. Regarding the Gmail setup on January 9, 2023, Juliana told the Commonwealth that she was at the house with Brendan when she witnessed him create the Gmail account that was used to kick off the entire catfishing scheme. The Commonwealth took her at her word. The police didn't make any effort to corroborate her story. The one detective who stood up and said the evidence contradicted her story was transferred off the case. I think the words were from then Deputy Chief Bruce, that guy will never work on another digital forensics case in major crimes as long as I'm here. He admitted it. There was no dancing around. He admitted it. So you have something that's in opposition to whatever the theory is that you're trying to peddle, and you're in the command staff, you're high up in the police department, you can just transfer him. And so it was from that point on, Detective Miller was of no benefit to the police because no one would utilize him once the stamp of disapproval had hit him. He was moved over to child sex. Juliana told the same story to you here in court.
I'll be
And
right
it's a
back,
lie.
chat.
The account wasn't created with Christine's phone. I'm sorry, the account was created with Christine's phone, not her laptop, which was the story that Juliana had told. Juliana wasn't even home. She hadn't witnessed anything. And you saw the presentation, and that would be, the evidence would be Exhibit 297, Exhibit 294, and Exhibit 295. They're all in relation. You'd be looking at the Google records, the T-Mobile records, and the subsequent map of where the location was. You heard from Mr. Litsky that the Gmail account is crucial. They all interact. The Gmail account is necessary to get the messages relating to the FetLife. And then the Telegram was created as part of this, whatever we want to call it at this point. Juliana made it up. She told the Commonwealth what they wanted to hear, and without question, they just took it as their story. She told this lie to secure herself a deal that benefited her. This one event relating to digital forensics is reasonable doubt, because every other event going forward requires Brendan, based upon her statement that she didn't have anything to do with it, she didn't know how to do the Gmail account, she didn't know anything about the setup, requires Brendan to be involved, or Christine. So let's look at this. There was a period of time, and you heard evidence of it, Brendan wasn't at home. January 23rd, there was a Gmail login at 11:22. That's Defense Exhibit 245. FetLife was accessed. In the communications, you heard Mr. Litsky opine as an expert that catfishing is not a scheme where one talks about their husband or talks about how's your experience on this site. Catfishing in the truest form of the government's theory is we just want to get someone on the hook, and then person's gonna come, and then we're gonna do what we did in there in the house. It's not consistent with catfishing. And you'll see, based upon the records relating to January 23rd, there was only one adult in the home at that time. And that adult was Christine Banfield. January 30th, there were two Gmail logins, 10:36 and 11:03, exhibits Brendan Banfield 251 and Brendan Banfield 252. Brendan wasn't home. That can be shown. So there were two adults in the house, Christine Banfield and Juliana Perez Magalhães. Juliana testified to all of you. She doesn't know anything about the Gmail. She doesn't know how to activate it. Well, somebody activated it that day. Somebody logged in twice. And there are two adults in the house. Either Juliana's lying again, and she did figure out how to do Gmail, or this was Christine Banfield. Digital forensics, oftentimes, for people who don't understand it, will say things like, well, isn't it possible this? Well, you see what happens when an investigator is looking into trying to get attribution. They're looking at all sorts of different data facts in order to make a determination, make an opinion. It's not as easy as saying, well, isn't it possible this? There's more to it. And once again, digital forensics is not being given the strength that it is due. February 7th, 2023, Gmail login at 10:02 p.m. There's only two adults in the house. Brendan Banfield can be identified as being out of the house, and one of whom says she never did anything with Gmail. That's BB 257. It's been presented to you. You can recollect what it was that was said, but what we know is that Brendan was out of the house. What we know is that Juliana was there, and we know that Christine was there. February 13th, 2023. There are logins in the morning in the 7 a.m. hour. Well, what we know from digital forensics is that Brendan left at 6:05. And at 6:12, he was at Tyson's Corner, based upon his Easy Pass records. At 6:17, he was already to Alexandria. And soon thereafter, he was in Cheltenham, which is the Federal Law Enforcement Training Center. They call it FLETC. Well, while he's on the road, while he's at the FLETC Training Center doing his training, there are 2 logins. And there are 2 possible adults there. Juliana Perez Magalhães, who has said she doesn't know how to do that, and Christine Banfield. 2:17, you'll see Gmail logins at 11:19, 11:23, Exhibit 262, 263, same thing. 2 possible adults. Brendan Banfield was out of the house. One said she never did anything with Gmail. A fact that I think is very important in the discovery that was provided, both to Juliana Perez Magalhães as well as my client in preparation for her trial, FetLife was in the discovery, but Gmail was never in focus. Never in focus. So her testimony, there's a comfort level with FetLife because she saw it in discovery. She didn't see the Gmail. And isn't that a coincidence that when asked any details, she says, I don't know. When she says, I don't know, for 5 or 6 questions, I hope you recall it, I recall it vividly. She said, if you keep asking these questions, I'm just going to say, I don't know. And she continued to do that. Were my questions challenging, like the kind of questions that a detective might do? No, we were just looking for details. We were looking for details because we wanted to try to iron out what are these situations here. She was unwilling. She didn't know, but she knew I was digging for something. But if you look at the way she testified to all of you in direct, she was led to a certain statement or a certain fact, and she stated it. In cross-examination, I asked anything about that. Do you know who was in the house? Do you know where you were? Were you on the phone on WhatsApp with Christine prior to that? Where were you located at the time that this call took place? I don't know. I don't know. If that's what it says, I don't know. You know, there were a series of similar answers. Once again, her role has grown in importance for this case. It's, along with Deputy Chief Bruce and Lieutenant Giacchio, she's pushing it on through her deal. Now, one of the things that I talked to you all about, and one of the lengthy cross-examinations was relating to a group of exhibits which were number 1 through number 69. And you'll see it. It was highlighted. I think you've seen it for a brief period of time, but we were moving along. Look at that. You'll see these are the personal letters that she would write to my client. And those personal letters, I believe, is the closest to the truth that you will have heard from Juliana Perez Magalhães. She was in a situation which really was affecting her. And it would affect anyone. And she was telling you how she was feeling. She was telling you what she thought. There were things that were relevant to this case. They're trying to make me turn on you. I'm not going to do it. I don't have anything to say. There's nothing that I can do to help them with. And then you'd see letters as the time went on. I don't know if I can live like this anymore. I think it's better for me to end. And then as she gets closer to a preliminary hearing in April of 2024, you start to see real angst and real worry. And they're coming to her and asking her if she'll testify against my client, because that's what they wanted from the beginning. She was a pawn in trying to get to my client. You'll see this timeline in these letters. It goes toward July. July was the date of her first trial. And you'll see, and I'm not suggesting what she's saying about her lawyer is correct, but it was obviously something that was on her mind, and she didn't feel like she had the support At that point, if you think about it, the only support that she was having was from Brendan. Brendan was not arrested. Brendan was there communicating with her. Brendan's mom was actually supporting her lifestyle in the jail in terms of commissary, things like that, and also supporting her by having paid for a lawyer.
They were almond cookies.
Around August,
Very good, actually.
you'll see in these letters, it gets to be real despair. And then you can almost see hope just drop right away from her when
Not
she
a bad
hears that Brendan's
choice.
arrested. And then she testified. She went into the hospital from October 13th to October 23rd. And as soon as she's released and back to the jail, the deal is done. She's told, if you testify against him, we'll recommend time served disposition. She can go back to Brazil, be with her mom, create her new life. And we know a little bit about the new life that she's planning on creating. And you have it in the documents that are before you. She's been negotiating with people who are connected to Netflix. She's been negotiating with people who are connected to Hulu. She's been talking to every other news media at first to try to see if they just put $50 into her commissary. But then she realized, hey, there may be something here. She's invented, she's going to try to write letters. She's going to try to write a book. She wants to have a documentary. She wants to have a series. And she's about to sign or about to agree when her lawyer steps in and says, don't sign that. And so around March of 2025, you see negotiations essentially end. The number was in the area of $25,000, and it was going to be sent to her mother in Brazil. It's a lot of money in Brazil. And so where's the downside for her? Where's the downside for her? I mean, there are plenty of people who would make that decision, given the circumstances, given you're 2 weeks from the trial, when your attorney asked for a continuance. And oddly enough, he was asking to find a digital forensic examiner. If they'd done that, maybe that wouldn't have happened. Maybe they would have realized how strong the digital forensics examinations are. Her entire story has been bought and paid for. First, with her freedom, and then now a little bit on the back end. There's a jury instruction here that says something about corroborated, uncorroborated testimony, and you should be careful of it. Now, how did they try to corroborate her? So isn't this funny? They're trying to bolster the witness who's the centerpiece of their entire case. Well, they found something when my client was arrested on his laptop that said they'd just gotten vinyl light windows in December. So sitting in the meeting with whomever, they say, can you tell us anything about these vinyl light windows? They're triple paned, probably really good. I wasn't there, I don't know. But the story she gave was that, fantastic. We got the triple pane windows because Brendan wanted to make sure you couldn't hear a gunshot in the bedroom. And and she says, he asked me to go outside and scream to see if the windows, and she says, I'm not going to do that. So she ended up staying inside and saying Brendan went out and screamed. Well, you heard the test. This gentleman from Vinyl Light Windows came in, they trotted him up there, and he said, yeah, we met in January. That was when we first talked about this, and it wasn't just the windows for the bedroom, which is what Juliana said. It was the full windows. And then you saw an artifact on Facebook that is Christine Banfield actually talking to her neighbors about the numerous vendors that they had been working with to try to get a quote from December 2021. So this is well before Juliana came on the scene, but it's an opportunity to try to make her appear in the know, to corroborate her. Well, that was a disaster, and that didn't work. And you heard the gentleman, what the life cycle of order to quotes to all those things, they were all done well before any sort of relationship started with Brendan. Confirmation bias. Rush to judgment. It continues on. Detective Leah Smith tells us the catfish theory was told to them within 2 weeks. She goes on to talk about the theory and investigation and the direction it was going in. During a period of time soon thereafter, Detective Miller tells of his transfer against his will because he was advised he'd never work on major crimes cases again. Sergeant Ames, after receiving communications from Lieutenant Giacchio, immediately sends it up the chain. Could be just the way he does things, or it could be, read those emails. Hey, I'm being asked to do this. I need some support here. When you have a theory that gets pushed from non-investigative command staff, and you have a theory that the investigators look at, then you create something called tunnel vision. And that tunnel vision, if you're following what essentially are orders, is to the exclusion of any other evidence, any other theory, such as maybe this is a rekindling of previous fantasies, and the guy who brought the knife to the house is the stabber. You can see how that theory is going to be pushed aside. And you can see how that's not very noteworthy for purposes of media or other attention. Once again, rush to judgment. Catfishing. If you're catfishing, meaning you're trying to get the one guy, Joe Ryan, to come to the house so that you can do this gruesome act, why are you saying anything about, I can't have marks on my face or my body? If you're catfishing, why would that matter? It doesn't make sense. It's inconsistent. However, if you're interested in dabbling in this lifestyle or getting back into it, however you want to say, then that makes perfect sense. There's 9 different conversations on FetLife with different people, and you have all of the FetLife communications. And you can see, why would you have discussions where you're bringing things like no marks, anything like that? All you need is one if you're going to carry out what the government's theory is. Why would you give anyone details about your work or your home or your husband if you were catfishing? I mean, if it's truly catfishing, you're looking for the biggest pile of people that might be considered. If you're telling someone that you have a husband and you want them to come over to the house, why would anybody come? You're losing the potential people that you might want to have there who are violent or, love to do all the things that Juliana has said. Why would you do that if you're catfishing? It doesn't make sense. On February 13th, 2023, why would there be generic recent search on secure apps for communications? In fact, why was there even a need to transition to Telegram? Because if you're on FetLife, it's clear there are FetLife communications. And so in the world of catfishing, if you think about it, you want to do as few things that can get you caught. So what was the leap to Telegram? It doesn't make any sense. In fact, this whole theory doesn't make any sense. And the only way the government can make any sense of it is if Juliana Perez Magalhães adopts their story. Once again. As late as February 19th, which would be 5 days before Christine Banfield's death. Under the government's theory, there were dates that were being explored with 5 different FetLife users. Why? If Joe's already coming, why? It doesn't make sense. It doesn't make sense. Juliana Perez Magalhães is doing what probably anyone would do who's from another country, who comes here for an adventure, which is what au pair exchange is. It's essentially a cultural exchange. And the idea is you get to live in the country.
It's not a
and you get to
cultural
live like
exchange.
people in the United States.
Stop.
And then you go back at the end of your time.
Bruh.
She knew at the point when she was hospitalized to the point of sickness as a result of what was going on in her life that she had to do something. And the Commonwealth and the police broke her. She turned down a misdemeanor, according to her, in January, on January 1st, and you'll see it in the communications. She turned down a misdemeanor, and all she had to do was testify against Brendan. In July, you hear her recounting her meeting with her lawyer, where her lawyer floats the idea, well, what about a manslaughter, time served, and you don't have to testify against Brendan. She agreed to that. That was never what they were talking about. That was never what they wanted to do. You heard from Sergeant Matt Nilsson, who briefly came in, and he was one of the homicide people during the time of the killing.
They call it a cultural exchange, but it's basically indentured servitude, cheap labor.
Of Christine Banfield. He's since rotated out to another division. But he came in and he said the whole goal of arresting Juliana was to flip her against Brendan. Once again, further corroboration. We knew it. We saw it from her letters. And now you have someone who was involved saying, yeah, that was what we wanted to do. That's why we did it. They broke her. In talking about the blood work and the blood testimony, it was suggested by the Commonwealth that we hadn't proven anything. The Commonwealth had not shown anything. Well, I beg to differ. You heard from Leanne Singley. Leanne Singley is an expert. She's an expert with tremendous credentials, and she's an expert in truth in terms of what she's allowed to say, what she can say, what she can't say. And she speaks to you in the language.
If it makes you feel any better, most of these normies don't know it well either. He's a boomer. It doesn't help.
Of bloodstain pattern analysis. She's not talking about possibilities. She's talking about facts. She's a scientist. Her counterpart from the Commonwealth was willing to entertain any possibilities. In fact, questioning of her was, well, isn't it possible this? Isn't it possible this? Isn't it possible this? And oftentimes you would hear her respond, well, that wouldn't be something that I would have expected to see, which is a very interesting statement if you think about it. What is it that she's expecting to see? Which makes you wonder, who's telling her what she should be seeing? And does it fit the narrative? So let's go to Leanne Singley. She tells you, of the account of the events, Ryan stabbed Christine in the neck. Brendan shot Ryan in self-defense. Brendan rendering aid to Christine. Ryan moved toward Brendan and grabbed Brendan's arm. You see that in the videos. And Juliana shot Ryan to end the threat. What Leanne Singley tells you is all of the blood evidence supports this. Ryan brought the knife. That'll be Commonwealth's Exhibit 10. The knife has blood on it with Christine's DNA on the blade and Ryan's DNA on the handle. Ryan has Christine's blood on his hand as well as a puncture wound, which the medical examiner says is consistent with the knife. And if you look at the knife, it's described in the certificates of analysis as testing underneath the handle by the edge of the blade. And if you look at the marks on Joseph Ryan's hand, the medical examiner states that these wounds are consistent with that knife. Which reminds me, the medical examiner also said that Joe Ryan was capable of movement. And you can recall your own notes on that. That was very clear, which is in absolute conflict with Ms. Groff and is in absolute conflict with the Commonwealth's theory. She further goes on to say, Ryan has the blood on his hand shows his hand was closed when the blood was deposited. That's that closed fingers we were talking about. That's what the Commonwealth was talking about in terms of having nothing going in between the fingers. That's holding a knife. That's how that happens, because you're holding it very rigid in order to do that. The bloody handprint on Ryan's thigh is consistent with him touching his own leg with his bloody hands. That's Ms. Groff. The stains on Brendan's jeans and shirt are what you expect he would get while giving aid to Christine. And we see it. We see it on the body-worn camera. We see it on the still shots. He's leaning down. He's down there on his knees. Interestingly, Ms. Groff says, all I saw was his hands around Christine's neck. I don't know that that's not accurate, but that's probably not what was really going on there, because everyone else said he was rendering aid. The police witnesses, who are more objective than the expert witness for the Commonwealth, all say that he was rendering aid. Testimony by Ms. Groff and the ME indicated that Ryan could move after the gunshot. And what's most important is that there's a DNA mixture of Christine and Ryan on the arm of the jacket where Brendan said he was grabbed. 3 times. 3 times.
That's not really going to get you there.
Told by the first responders, go into the bathroom. He said, they're asking, is he okay? He hit me on the right side under the shoulder blade by the arm. He said that. Then in the ambulance, you'll hear that. He says, when they're asking, are you okay? Are you okay? I don't think I'm injured.
You could talk about things that aren't in it. Like, it depends on what you mean, Erica. But you could say, why wasn't this there? Why wasn't that there? But if you start talking about facts not in evidence, like this happened, and you're like, wait, I can't, that wasn't proven. The other side might step up and object. It all depends. You're not supposed to, though.
But he did hit me on the backside of my jacket.
Good question.
In the ambulance, they grabbed the jacket. And then when he was in the hospital, the doctor asks, and he says, he hit me on the back, but I'm not injured. The critical part of that is that the DNA mixture of Christine's blood and Joe Ryan's blood on the jacket was, if you were listening to my client yesterday, he tells you that that was Joe Ryan after he shot him. That mixture of blood with Christine and Joe Ryan himself had to be after Joe Ryan had stabbed Christine in the neck. And that's the way her blood would get on him in order to be able to get the back of my client's jacket. That's what the Singley says. And that's why the Commonwealth is so intent on saying this had to have been on the floor, this had to have been on the bed. But there's no evidence to support that. There's a story to support it, but there's no evidence to support that. The evidence in terms of what happened in that room, and the crucial evidence, is spot A on the back of the jacket, and you have it in evidence, and you also have it under Commonwealth's Exhibit 160, 161, and 167. Now, let's just talk a little bit about the prosecution's evidence. Brendan's DNA is not on the knife. That's also supported by those same forensics reports. He doesn't have any injuries to his hands. That was confirmed by EMTs. In fact, poor officer, I'm sorry, the young man who was 1 year on, I forget his name now, he was brought up to introduce his video and then was asked, well, why'd you let him wash his hands? And you can see my client, for a period of probably 40 minutes, is literally walking around, you know, in a trance from what he was just involved with. And he was walking around with blood all over his hands. And it was only after he was told that his wife had died, and the emotions that come from that, where he was blowing his nose and wiping his eyes and doing all those things, it was offered for him to wash his hands. But that appears to be some sort of a horrible thing that this officer allowed him to do. And it was even an insinuation that my client was trying to cover something up. This was 45 minutes later. It wasn't as though he went into the bathroom and did it right there after being removed from rendering aid. Brendan's DNA does not show up anywhere on Joe Ryan, which is consistent with what he told you, which is that he never touched Joe Ryan. There's no indication that there was any sort of movement. And frankly, what's the possibility, I guess I'll use the same word, that a 185-pound man would have been moved if he was otherwise dead? It's not an easy task. And Brendan Banfield's an athletic guy, but I don't think he's up to moving 200 pounds in that sort of way. So that's an absolute red herring in this. When
Mr. Kirst. Do you have quite a bit more? I just want to give you a chance to.
Probably about another half hour.
Yes, let's go ahead and take our morning recess for 15 minutes. Please do not discuss the case at this time and do not do any outside research.
Oh my God. We're gonna take 15 minutes here. Here we go, chat.
We left off in the discussion of the bloodstain pattern analysis. And what was an interesting moment in terms of the experts was when there was talk of bloodstain inside the zipper and around that area. But if you look at the DLI report, which is number 169, you'll see in that report, they were looking actually for touch DNA. They weren't actually looking for blood staining. They identified blood staining, but the whole point of it was to find Brendan Banfield's touch DNA on the inside of Joe's pants based upon some theory that he was either pulling the pants off or moving them or something like that. And that was one of the reasons why they went to a private lab to try to do that, and it didn't pan out. And you'll see the report. Now, in terms of the evidence on the bloodstain pattern analysis, let me just do a rundown. With regard to the knife, it was identified as being bloodstained. Leanne Singley said that. She negated the possibility of anything being wiped off, which might be one of the things that you might find in a situation of the nature of the government's theory, but she's negated that. That it contained DNA of Christine and Ryan, and Brendan was excluded. That Joe Ryan's DNA at the base of the blade, handle juncture, that was the testimony of Leanne Singley and also confirmed by the Division of Forensic Science. That Ryan had a puncture to the left thumb. That was Leanne Singley's testimony, as well as the medical examiner, Dr. Kessler, confirmed that. It was consistent with the knife, Dr. Kessler said, and it was consistent with the self-wounding that happens in situations involving stabbings. And you heard Leanne Singley touch on that, and she was able to kind of give you a more circumspect view of what self-wounding was. I think Ms. Groff talked about slicing, fingers or sliding or something like that. What we were looking for, and what I think Leanne Singley was able to tell you, is that there are a wide variety of injuries that occur, but oftentimes the stabber is someone that's injured. And I think there were significant statistics that she talked about, which I won't try. You'll have to rely on your recollections regarding that. You saw on the body cam footage, as well as through Ms. Singley's testimony, that Brendan does not have any injuries on his hands. And Ms. Dolly's testimony indicates Ryan's right hand closed when blood was deposited on it. That's consistent with Ryan holding the knife when stabbing, causing bloodstains. Joe Ryan, there's a lot to be said, and I think you've already seen pictures of it in this closing, of the 4 stains on Ryan's forearm. What hasn't been said is that they were not tested. Leanne Singley says they're not able to be classified. Ms. Groff disagrees, saying that they are drip stains. She needs to say they're drip stains, which Leanne Singley says you can't say because you don't know the position of the arm. You don't know where it was at the time the blood came out. It could have been something from a significant bleeder as he's standing up. It could have been from numerous other possibilities. But Ms. Groff classifies something that Ms. Singley says you can't classify without certain factors, suggesting that it's falling from above and has Ryan on the floor. One might think you'd find the source of whatever that blood is if you're to have tested the blood that's in question. That might give you a little more guidance. And I think that's one of the reasons Leanne Singley was unable to identify that. If it was from Joe, then she'd probably have some explanation for that as an expert. If it was from anyone else, that perhaps could be a different explanation. But now all we deal with are possibilities. And that seems to be the crux of how the Commonwealth is pursuing this case. They're not putting on any evidence in terms of their own investigators. They're not providing any concrete evidence as to what happened that day. And interestingly enough, the shift in the last closing argument was that I hadn't been doing that. And the defense hadn't been doing that. But I think we can all agree that we've called significantly greater number of police witnesses because we had to. Because we want the truth out here. called my client, though he has the absolute right not to come up and testify. And he testified. And the relationship issues with Juliana Perez Magalhães are touchy, and they're an awful story. But he sat there and he answered the questions. He was cross-examined. He answered those questions. We're bringing you the truth. We're trying in every way to get the truth. And many of the Fairfax County detectives have provided that, and that goes to their integrity. The genes, the touch DNA from the waistband zipper indicate Joe Ryan and Christine Banfield are the contributors. Brendan Banfield is excluded. All samples collected and tested on Ryan were from Joe Ryan or Christine. Brendan not identified as a contributor in any of them. Nothing in the materials reviewed gave any indication that Ryan was not the stabber. That was Leanne Singley's testimony. Brendan's jacket, blood on the rear of the right sleeve, DNA on exterior of right
Pull us
sleeve,
up,
mix
Dad.
of Ryan and Christine. Brendan indicates that Ryan grabbed his arm on Officer Beckner's video, Officer Baumler's video, in the ambulance, and also in the hospital. Brendan's jeans, the small stains on the thigh is consistent with cast off from the hands. That's Miss Dolly, Miss Groff. Brendan sat in the bathroom, if you look on the video, and the first responders arrived. He was basically told to sit on the tub, and you see him when you look at that video, and he's sitting there, and he's just, hands down, not sure where his hands go, and he was watching as his wife was being tended to. The stains on Brendan's jeans are consistent with him kneeling at Christine giving aid. That's what the body cam video shows. Back to the digital forensics for a moment. February 19th was a critical day because that was the beginning of the Telegram account. Juliana says she watched Brendan. They stole the laptop and the phone. They deleted the two-factor authentication code, but the two-factor authentication code remains on the phone to this day. And this is Defense Exhibit 156. Is it possible that Brendan and Juliana did this without Christine knowing that a Telegram account was opened in her name? It's not, based on this exhibit. Because if you look at it, and you can look at the message from Telegram, shows up right underneath a message from Brad of Innova PICU, and right above a message from Nicole at Innova PICU. It was done early in the morning. If it had been done by someone other than herself, as soon as she looks at that message from Nicole, she'd realize something's going on. I should check this out. Inconsistent with catfishing, inconsistent with someone pursuing a fantasy. February 23rd. We saw digital forensics evidence from the evening of February 23rd. We saw use of Christine's laptop for 90 minutes for resort searches, with a couple of minutes of Telegram use interspersed. The Commonwealth in cross-examination opined, well, wouldn't it be possible that even if you were sitting in the same room, that she could have gone away to go to the bathroom for 2 minutes? And I guess, in this world, anything's possible. Is it probable, however? And that's really the more germane point to this. The Commonwealth's, I guess, concern in cross-examination was confirmed, at least in terms of the room, when Brendan testified. And if you recall his discussion, we were talking about, we were already going on a cruise and we were talking about going to the Dominican Republic. We saw the calendar that showed the place, Royalton Resorts. We showed searches that showed kid-friendly vacations. So we knew who was behind the keyboard, and Brendan knew who was behind the keyboard because he was there with Christine. And they were collaborating on the vacation research. Brendan was playing with Valerie, and Christine was on the couch with her laptop and her phone. That's the testimony. The device's symmetry and connectivity you heard about has the context to complete the entire picture. Juliana was not in the room, and this is supported by the analysis on her phone, showing a steady stream of messaging, social media use, and Netflix at the same time that Telegram, FetLife, and the suspect Gmail account were being used by Christine. And finally, February 24th, Juliana was not awake, not out of bed, based on her devices at the time she claimed to be watching Brendan Banfield sending messages in the kitchen. You heard Mr. Litsky talk about her Apple Watch. You heard him talk about her phone. We're showing when steps were showing, which would be an indication of someone moving. She had not moved for some time after the laptop was accessed. What we know from the testimony yesterday was that Christine Banfield had the laptop and the phone in her bedroom and was awake when he went up to retrieve Valerie. That is an artifact in the world of digital forensic analysis. And you'll see this entire exchange, Defense Exhibit 348, 349, 350. You'll see Juliana Perez Magalhães' first steps at 626. Defense Exhibit 351, 352, and 353. Juliana Perez starts her day after the telegram message is already sent. In conflict with what she's told, in conflict with the story that she's adopted on behalf of the Commonwealth. Brendan's at McDonald's. Exhibit 354, 355, 356. Those are timestamped screenshots from the McDonald's videos. Juliana is on the phone telling us her phone tells us that her activity stops at 7:24 under Defense Exhibit 357. At the exact same time, her watch steps are stopping at 7:24. Defense Exhibit number 358. Defense Exhibit 359, Juliana steps resuming on the phone at 7:41. Exhibit 360, Juliana, car is parked at 7:41. Exhibit 361, Juliana's watch resuming steps at 7:42. We know that Brendan was out of the house. We know that Juliana was in her car. And if you look at Exhibit 362, there's someone who's logging into Christine's laptop at 7:33. There are no other humans in the house. And Juliana and Brendan were not there. In conflict with the government's theory, Christine logs into her laptop and places her devices in a drawer. She puts the devices away. She gets Lily down into the basement, brings her food to the basement, and gates her in. And she meets Joe Ryan. And they walk up to the master bedroom. Why? Why would Joe Ryan stab Christine? If you take away the consensual part of this, if he were found in a bedroom of someone by someone who's a police officer, he'd be looking at a life sentence. In this instance, he was confronted by an armed law enforcement officer saying police. That officer was
Which doesn't make any sense
only
if you're the
way to
guy.
get out of that
Why
room,
is there a cop here?
other than jumping through the window and falling down 3 flights. He had a gun trained on him, and he was telling him and was told that he
Reach
was gonna be
for the
arrested.
sky.
He had marijuana in his system, and he was angry. Who was he angry at?
Wasn't angry at anybody.
Could he have been angry at Christine, thinking that she set him up? Could he have been angry at his situation for deciding to go into a house that he didn't know and put himself in this situation? Could he be angry at my client, who was there to try to figure out what was going on and ultimately try to protect his wife? Those are the whys. And if we'd had any investigators that were actually involved in the case coming to the stand, those would be questions that I would want to know, and there would be questions that you would want to know. Because you have a decision before you, and that decision requires a review of all of the evidence. Now, is it reasonable after a 6 to 8 week affair that someone's going to try to get rid of their companion of 19 years, wife of 12 years? Is that reasonable? You heard from my client, he thinks it's absurd. In pursuing this case, the Commonwealth has presented absolutely no forensics evidence that supports that Brendan Banfield had anything to do with this, yet the story continues. This isn't how justice works, and you can't just come up with a theory and make it fit. They're trying to sell you a story without any facts, and we have the facts, and those facts are in evidence. Those jury instructions, when you see them, you'll realize they're very clear. If you have doubts about the investigation, if you have doubts about how they've conducted this investigation, if you believe that there's something that's been held back in this investigation, that's reasonable doubt. That's reasonable doubt before you even get into the things that negate the possibilities of their case. And these are hard decisions. There's a lot on the line. But know this, if they fell short in what you expect should be the investigation, if they fell short,
This
that's
is the
not on
big
you.
point.
The jury
Hold the
instructions say you
investigation
must
out.
acquit. And it's not on you.
That person is also okay with sleeping around too.
I don't have another opportunity to talk to you. It's their burden to prove this beyond a reasonable doubt, so they get the opportunity to speak. So I apologize if I've gone too long, but I wanted to make sure that these important issues came before you. And I leave you with these words.
This is not normal speed, guys. Here, we'll do it normal speed. We'll do it normal speed just so you can listen. We'll go back about 2 minutes. Here's normal speed.
With this, yet the story continues. This isn't how justice works. And you can't just come up with a theory and make it fit. They're trying to sell you a story without any facts. And we have the facts. And those facts are in evidence. Those jury instructions, when you see them, you'll realize
He's got dark side film mode
they're
on.
very clear. If you have doubts about the investigation,
Yeah, see what you did,
if you
J-Rock?
have doubts about how they've conducted this investigation, if you believe
This is
that
normal
there's something
speed,
that's
chat.
been held
We're at
back
normal.
in this investigation,
We are at normal speed.
that's reasonable doubt. That's reasonable doubt before you even get into the things that negate the possibilities of their case.
Hey, J-Rock wanted me to go at normal speed, so it's what you guys get. It's what J-Rock wanted.
And these are hard decisions. There's a lot on the line. But know this, if they fell short in what you expect should be the investigation, if they fell short, that's not on you. The jury instructions say you must acquit,
You must.
and it's not on you.
It's robust.
I don't have another opportunity to talk to you. It's their burden to prove this beyond a reasonable doubt, so they get the opportunity to speak. So I apologize if I've gone too long, but I wanted to make sure that these important issues came before you. And I leave you with these words. When they lie and manipulate to get someone to make a statement, that's not discovering the truth. That's planting the truth. Ladies and gentlemen, thank you for your attention. Thank you for your patience. And at the end of your deliberations, I ask that you find my client not guilty of all charges. Thank you.
All right. Rebuttal argument. Switch over the mic again, Mr. Carroll.
Thanks. All right, just a couple of last words. Mr. Carroll has a really interesting recollection of the evidence. It certainly doesn't match ours, and I'm guessing it doesn't match yours. FYI, the lab for the coat was 165, not 167. And the DLI lab, it doesn't say anywhere on it that it was touch DNA. It was blood that they tested. Juliana did not repeatedly say that she didn't know how to work Gmail. She said that she did not create the Gmail account, that was Brendan. Giaccio and Bruce had the catfish plan and they peddled it and pushed it to everyone. I don't think that's at all what came out. I think that Mr. Carroll is trying to focus on the HR woes of the Fairfax County Police Department to distract you from the fact that the evidence actually supported that theory and that he has provided you, and his client has provided you with absolutely nothing to refute that theory. Why was there so much discussion and disagreement over the digital evidence? Because it could never be that smoking gun. You all heard it from their expert. You can't put someone behind that screen unless you're sitting next to them. So as much as we want it to tell the story here, as much as we want it to be the perfect evidence that proves beyond a reasonable doubt that this thing had to happen, the digital evidence just isn't that. We wish it were, but it's not. And Detective Miller did nothing wrong, and Mr. Lidsky did nothing wrong. They just told you the truth. And the truth is that they can tell you what a device was doing, but they can't tell you who was using the device. Juliana Perez Magalhães' testimony was bought and paid for. Yes, she pled guilty to a lesser offense in exchange for her testimony. Ms. Frissler made sure you knew that from the get-go. Juliana talked about that. She explained for her reasons why. Nothing was hidden. After her sentence, it sounds like she might have the opportunity to make, 10 grand off of selling her story. She said that she would use that to support her family. And then what? Is she gonna work as a nanny? I mean, she's a convicted murderer. Do we really think that it is so reasonable that she made up this complete lie for 10 grand? Really? If this version is correct, coming from Mr. Banfield, then she would be set free. She would be as not guilty as he would be. So she's going to give up that shot for 10 grand?
She's
I just don't buy it.
retarded.
Whose story is more credible here? Juliana's or Mr. Banfield's? Whose version does the rest of the evidence support? The defendant took the stand and he lied. And he lied about collateral matters. He told you that he had a big career-defining work meeting the morning of the murder. And then you heard from his boss who said, no, he didn't. He lied. He said that he and Juliana did not have a plan to kill Christine at the time that they went to the shooting range. Well, he said, not at that time. If he's lying about the things that don't matter, how can you believe a single word he said? And ladies and gentlemen, you have to do that in this case, because without some alternate theory, the Commonwealth's evidence is uncontroverted. So you got to pick one. Juliana, Mr. Banfield. Whose story does the evidence support? All of that blood, the DNA, to some extent, the digital forensics, the physical evidence collected at the scene. That's what you can rely on. Don't rely on his narrative and his recollection of the evidence. For that reason, don't rely on mine or on Ms. Frissler's. Rely on yours. It is your collective recollection of the evidence that you have heard that is controlling. You know what was said here. You know what the evidence is. We trust you to make the decision. Thank you.
Thank you, ma'am. Members of the jury, this is an important case to both the Commonwealth and the defendant. In order to reach a verdict, each of you must agree on that verdict. In other words, the verdict must be unanimous. The first thing you should do when you get back to the jury room is to select a presiding juror. The role of the presiding juror is to see to it that the deliberations are conducted in an orderly and businesslike manner. that they are conducted only in the jury room when all members of the jury are present, and that each juror has the opportunity to fully and fairly express his or her views. It is rarely helpful for jurors upon first entering the jury room to take a straw vote, or for any juror to make an emphatic expression of his or her opinion in the case, or to announce a determination to stand for a certain verdict.
All right, chat, that's it. Long story short, they get to the end of the day. No verdict still. 3 hours of deliberation already. And I'm like, well, that's embarrassing. I was not even close. So, yeah, that you'll have that. You'll have that, chat. So, oh. Does the presidential juror get a whip? No. They mean, like, that's the presiding, like, the foreman. They call it differently. So, yeah, I mean, like, this wasn't, the prosecution did not solidly close, but the evidence is on their side. But, yeah. Moments of Trading says, hay is for horses. You guys know what gay horses eat? Hay! 2.0's heard that joke a million times. So we'll probably find out on Monday. I can't imagine. He's probably going to get convicted while I'm in court. And if he does, we'll watch it later. So, are the courts open on Monday? As far as I know, I mean, like, we're not. I don't think it's going to be, you know, like tomorrow, like even tomorrow, it's going to be, tomorrow, Monday. Oh, wow. Actually, we have a pretty good outlook. We're actually going to get warm temperatures here finally. Like by Thursday, it'll finally be fucking freezing for the first time in like a month. So that'll be good. And then, we're going to get some snows tonight. We'll get some snow overnight. And, for a good part of Sunday. Good. Anyways, guys, that's kind of where we are with things. But no, it'll be open. If I'm on a jury and we get to deliberations, can we send this man to prison for life on the evidence other than the gun happy up Paris testimony? Yeah, there's a bunch of stuff that just doesn't make sense. Yeah, down in South Carolina, yeah, Virginia's getting more snow, but I think they'll be okay. I think it's going to be guilty, guys. I think that the admissions are going to be tough. And the whole story just doesn't make sense. And, the problem is, this is why you don't do the sketchy and weird, like, it's funny and weird. But the problem is, when you have to expect everybody else to understand it, nobody believes you. Like, this makes no sense at all to anybody who's not a complete fucking weirdo. Romeo, good to see you, man. Saying, no snow here since the storm ended. We are clearing out. Well, there you go. And that's in Southern Virginia. Okay. So, at least one juror will be all like, what do you mean it's not fat life? But so I think it's going to be a while there. You hate going to the bathroom. That's why you need a heated seat. That's why you get one of those bidets and it comes with a heated seat. It's always nice. Perhaps it is you who's funny and weird, Sar. Yes, maybe. All right, guys, so that's it. Let's see what the poll is. I don't know what you guys came up with on the poll now. Let's see. The poll was up 97 votes. Shockingly, 73% say guilty. Not a surprise at all. I think he did it. I think he was involved in it. I think she helped. Did you ever watch the other mom who hired Juliana? I didn't know there was another interview, Romeo. I didn't know there was another one. I didn't know about that. I was not impressed with the closing statement from Matlock. I mean, to be fair, there's only so many ways you can do this. But yeah, I mean, there's only so much he was going to do anyway. Costco sells a bidet toilet seat. Sweets and Phrases, what didn't make sense to you? I'm not saying it didn't make sense to me. I just think if he did a better job of doing it, yeah, if you send me the link, I'll play it. I just think the jury, like, it's hard to keep attention with people. it's hard to keep an attention span. So I think it's going to be tough to do it. It's going to be tough. But otherwise, I understand it. It makes sense to me. But I think the jury is going to be sitting there saying, listening to his closing, really.
It just don't make no sense.
It's just, that's what's going to happen to them. That's what they're going to hear. So they're going to say it just don't make no sense. Let me see here. Carol's representation could have been tighter and more engaging. Yeah, I don't know. I don't know how you could do that. I mean, there's only so much. Bananas and rice make no sense. Well, yeah. Okay, thank you, Romeo. Let's see here. Give me a minute. You'll find the. Oh, I thought you had it already. Fucker. Are we on pack watch? Yes. When we are at this time. Oh, yeah. This is going to be, we'll find out here soon enough, chat. But in the meantime, we're going to get the wet palette ready, and we're going to get the, I think Flash might be having, we might be doing Flashcast tonight, chat. So we'll just get ready for more Africa. Like, we got more Africa to paint, chat, and put together. More Africa. So much fucking Africa. So much Africa. We'll do a model stream in the meantime, yeah. Why didn't the defense blame Juliana for the whole thing? There's no way that would have worked. Like, because if they blamed her for the whole thing, Brendan, like, I think part of the issue is it's too bullshit. It's too bullshit. Stacy, what are you asking? Just don't know? What? It don't make no sense. It don't make any sense. So, yeah, we got more Africa. It's time for Africa. Yes. You're not a fan of Africa? Like the Africa Corps guys? Because, I mean, like, we also have to work on, since the finish, the shellac took a while on these, the armored car, the SD KFC 222. We actually have to put some decals on this son of a bitch, and I'll show you guys him in greater detail. And then also the 221, we're going to have to work on as well. And I put one on there, and that's when I found out the Army painter shit was only acrylic. So I was like, fuck, when I did the varnish. Let's see here. Let's see here. And Romeo's trying to work on. Say says the continent. Well, yeah, I guess, but yeah, it does sound like things are going to be spicing up out there. Out in the world. The ice raids, just the people trying to go after ICE took a big loss in court. All kinds of things happen. So let's see. What else are you guys? Any other questions? What kind of emergency comms do you have, Sean? We got Balfang and some other stuff. I mean, but that's really it. The pizza tracker is at 40% of something happening in Iran. Well, remember, we've got a lot of assets in the area still. So they were going ham on ICE yesterday in LA. Yeah, they were. Oh, yeah, they were. The police there were cracking skulls, and they were getting really mad about it. Oh, here we go. Former employer of accused au pair speaks out. Okay. Thank you, Rudy. Or thank you for Romeo. Here we go. We're going to watch this chat. We're going to see what this is. Okay. Waka, 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 waka. They were, yes, Erica. It was really bad in LA. Here we go.
Trial in Fairfax County, accused mistress and au pair was back on the stand yesterday to testify against her former boss and lover, Brendan Banfield.
Yeah, so he is accused of killing his wife and a man they lured to the family's house as part of a staged home invasion plot. Now, we saw a tense moment when the former au pair was pressed by the defense about remembering specific dates and details of the alleged plot. Listen.
How can I tell you? I do not remember the date.
I mean, with all due respect, you don't remember a lot of details.
Yeah.
That's what's really concerning about this.
Well, if you were in my shoes, you don't remember either. You know, your brain has a way to, defense mechanism it's called, and it protects you from losing your mind.
As testimony continues, the local mother is speaking exclusively to 7 News about her experience with that former au pair.
Yeah, she says the person she trusted with her children isn't the person she's watching on the stand right now. 7 News reporter John Gonzalez with us live outside the Fairfax County Courthouse with more on what she is saying. John, good morning.
Adam, good morning to you. Only on 7 this morning, Sarah Kerrigan Kent, a Fairfax County mother here, says she hired this Brazilian au pair, Juliana Perez Magalhães, a number of times. She used the platform, the app known as Bambino. It is an online app that allows parents to communicate with and screen babysitters before they are hired. Well, Kerrigan Kent says Magalhães babysat for her family for about a year and a half, more than 20 times before and after the murders. These are text messages, take a look, she received while her son was in the au pair's care 3 months after the crimes. She says the caregiver was so trusted, she even recommended her to another mother. Now, watching the trial, she says the woman on the stand is unrecognizable.
So I used her the first time and everything went really well. She played with my son. She wasn't just like putting him on an iPad and letting him like roam free. She really was engaged with him. She did activities with him. She was really, honestly, a great babysitter. So I found out because the other mother called me. So the mother that I had given the recommendation to, she ended up not showing up for work. And that wasn't typical for Juliana. Like, she had a very good work ethic.
Juliana.
And she ended up calling the police.
Kerrigan Kent also tells me Magalhães asked for a reference in the summer of 2023, months after prosecutors say the killings took place, and she found it odd that Magalhães never drove, always dropped off and picked up by a man she says resembled Brendan Banfield.
And when I knew her, she was very bubbly, very
Fucking
sweet,
creepy,
very
man.
enthusiastic.
Retarded like
But to know that I had someone in my home that was capable of this obviously doesn't sit well. It doesn't make me feel very good about my judge of character or something like that. But honestly, like, I don't think I could have really done anything differently.
This local mother has much more to share. We have the full interview on our homepage this morning. In the meantime, the trial moves forward. That divide, trusted caregiver versus accused co-conspirator, only growing sharper inside the courtroom. More on how day 2 went and what to expect in day 3, including those chilling 911 calls. Reporting live, John Gonzalez, 7 News.
Arguments pick back up this morning, and 7 News will bring you live coverage from the inside of the courtroom. Just scan this QR code.
Interesting, Romeo. Thank you very much for that. Yeah, what dumbasses. Yeah, they are. She taught my son how to shoot a gun and how to bandage, yes, and taught him how to use a computer. Tasmanian Rebel says, I know a Brit married to a Brazilian and living in Brazil. She's tried to stab him on more than one occasion. Sounds like a Puerto Rican to me. I mean, they like using knives too. Really, if you're going to be honest about it. If you want to know the truth about it. Oh. Marinette says if she's from Reston, that's average for here. Oh, wow. Oof, Reston called out. Yeah. Brendan is Captain Comb Over. Yeah, he's been reaped. He won't accept defeat. So once again, thank you very much for that. I appreciate the thing there. Wow. Well, chat, he's Norwooded. Oh, yes, he is. So with that being said, I guess we will check in on Monday and see where they are. In the meantime, we are going to head over to the model stream. We got some stuff we're going to work on and go from there, Shadow. Go from there. I'm just really, I really think Brendan's really only victory here would be getting her caught. And if they turn out that they want to claim she lied and they just fucking take her and they revoke her offer, like that's the only thing I think they could really do at this point. But I don't know. I don't know, chat. I just work here, so yeah. So there should be court Monday. The judge didn't mention it, so I think there'll be court. But yeah, this case kind of fizzles out at the end. We end on that high note of the boss testifying, and then all of a sudden, so this is what a judge once told me. He says, this is called a slow plea, and it is. It's a slow plea, but he's probably going to get convicted. If he doesn't, I am going to be very surprised. It ended on a loose fart. That's pretty good. So, chat, we'll go ahead. We'll get over the model stream. We'll get the models going. I got to get this wet. I got to go get this nice and wet. We'll get some decals on the vehicles. And we're going to probably start watching some riding tonight. So we'll get all on that. Thank you again. Thank you, Romeo. Thank you, everybody who super chat. Oh, Stacy says, how are our ships at sea? How are they going? Yeah, hold on here. I could do that too while we're at it. As far as Iran goes, I recommend this guy to follow. Ian Ellis. He is a he shows a good breakdown of the ready groups and everything that's going on right now and all the stuff that's in the ships operating in the Red Sea region right now. Here's a basic breakdown of what's in the Red Sea at this point. Since we're talking about some World War III stuff. Here's everything in the Middle East right now. And we're going to zoom out. We're going to zoom out a little bit more, chat. So what do you have? You have the Abraham Lincoln. It's out there. It's got, its 3 destroyers. It's got its oiler and support ships. These are these are LCS ships, and they don't really carry Tomahawks. These are all Coast Guard cutters. They don't carry VLS. And right now you have, in one place or another, 1, 2, 3, 4, 5. And notice this is the USS Roosevelt also. This is from one of the younger Roosevelts. I think it was Roosevelt's kid. But that's in the, Strait of Hormuz region, or they're in the Red Sea, or they're out in the Mediterranean. So there's a bunch of cruise missiles options available. There are some cruise missile options available. There's also the USS South Dakota, which is, and remember, there's also a submarine with carrier strike groups. U.S. carriers do not go to sea without at least one hunter-killer SSN submarine with it. It's always there. There is always at least one, sometimes 2. So there's also a submarine here. But then there's also an SSGN. This is an Ohio class that got converted to Tomahawk carrying. And then also there's just another SSN out in the area. So there are, maps, things ready to go. Let me see what I can. This is Skizzo Intel. It's the guy also I look at here. Here is another thing here. This is from Ian Ellis, this guy on Twitter. He talks about all the stuff we have right now. He brings up the ships that are in the way. Everything's at Al Udeid. We also have stuff at there's an NSA operation. We have stuff in Jordan. The RAF is in Cyprus because that's where they operate out of. There's Prince Sultan Air Base, Camp Lemonnier in Djibouti. And this is just a bigger visual representation of everything we have. Right now, the forward deployed assets in EU and CENTCOM, there's like 70 F-15s currently deployed in the area. There's like 50 or so available F-35 Lightnings. A lot of those are deployed out of RAF Lakenheath out of the UK. We still have military bases in Britain, if you guys weren't aware. And yeah, there's a lot of support going out there right now. There's 2 squadrons of A-10s in Jordan. And just look at the total Tomahawk land attack missiles. 454 total VLS cells in the EU and CENTCOM is over 1,000. There's a lot there. There's a lot available, chat. There's a lot available. And remember, this Georgia here, it's a Trident missile submarine. They switched to Tomahawks, so it's got a gajillion of them. And then the Abraham Lincoln, it's got 9 squadrons on it. It's got a squadron of Growlers. It's got 3 F-18 squadrons and 1 F-35 squadron. And then it's got like an E-2 Hawkeyes. It's got a couple of Ospreys. It's got a lot of stuff. A lot of stuff. So there's a lot of things here ready to go. A lot of things ready to go. Yes, one ping only, Vasily. It's basically an airbase and paperwork detachment. Well, thank you. I appreciate that. Where's the USS Baldo? It's operating in Minneapolis. Is it your booty? No, it's Djibouti. It's the Chinese are in Djibouti. It's the 5th Fleet. Thank you, Eric. At least one sub. How many Doms? No, they're all in FetLife coming over. Is the Gettysburg out there? No. 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 It was named after FDR. Are you sure it's named after FDR? I thought Teddy's son got one too, because didn't one of Teddy's kids win the Medal of Honor or something? Do you think Israel will strike first, then the U.S.? Well, I mean, Israel spent, like last year, they spent like a month where they struck like every other night and flew raids into all over Iran into Tehran. So, I mean, remember, Iran suffered a lot of crippling attacks already. So we don't know. But anyways, chat, we're going to leave it there. I will see you guys on Monday for the Banfield stuff. We're going to get over the bench now. And just remember, until next time, just because you did it does not mean you're guilty. Although Brendan Banfield's guilty. So he's, yeah, he better get ready for the honey buns, because that's going to be his delicacy going forward in life for the rest of his life. So good night, chat, and I will talk to you guys later.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fact